Hi, I'm Russ Weninger. I'm a wills and estate planning lawyer in Calgary, Alberta, Canada. Today I'm going to talk about the people you should likely consider to be good candidates to inherit from your estate. If you are married or in a common law relationship, your spouse or partner should almost certainly be a beneficiary. If you don't have children, or this is your first relationship involving children, then it may make sense to appoint your spouse or partner as the sole beneficiary. If you are single, widowed, or divorced, but you have children, your children should probably be at the front of the line to receive gifts from your estate. Second marriages can complicate things a bit. If you get married later in life, you may end up prioritizing your children over your spouse. If you remarry while you are still young, you likely still want to provide for your children, but you may end up giving a larger share to your spouse. Sometimes a separation agreement with your former spouse or a prenuptial agreement with your new spouse will put some constraints on what you can do with your estate. If you are married or have children, siblings and parents should probably not be at the top of the list of beneficiaries. You should typically be prioritizing spouses and children over parents and siblings. However, if you have a disabled parent or sibling for whom you are providing care, then you may want to provide for that person in your will. Parents and siblings can often be alternate beneficiaries who will only receive assets from your estate in the event that your spouse and children die before you. Single people often leave their estates to their parents or siblings. In some cases, close friends may also be considered as possible beneficiaries. If a single person gets married or enters into a common law relationship, they should consider redoing their will as soon as possible. While it's a noble thing to leave your estate to charity, if you have a young family, they should get priority over any worthwhile cause. I typically don't recommend that people with young families leave significant gifts to charities, since it takes a tremendous amount of money to raise a child to adulthood. Unless you are estranged, I typically don't recommend disinheriting a spouse. In many cases, a spouse will be able to bring a matrimonial property claim against your estate. In Alberta, disinheriting adult children is legally allowed, but in most cases it isn't a good idea. Disinheriting a child can negatively impact the sibling relationships of your surviving children. That being said, in some cases there may be good reasons to disinherit estranged adult children. If you live in a province outside of Alberta, such as British Columbia or Ontario, disinheriting a child may, in certain situations, result in a legal challenge to your estate after you have died. Please check out my upcoming video in which I will talk about how to pick an executor. If you enjoyed this video, please feel free to like it or share it or subscribe to my channel. If you have a question, please leave it in the comment section and I will do my best to respond. While I don't want to give specific legal advice in the comment section, I will try my best to answer general questions, provided it is understood that my responses to comments should not be taken as legal advice, that social media interactions are not considered lawyer-client interactions, and that your safest course of action is to consult directly with me or another lawyer if you have a legal issue or would like to prepare a will.